this presentation part. When we go into the breakout rooms, those are not recorded. You can ask questions during the presentation, but I ask that you do that via chat. So again, if everybody can please mute themselves, except for our presenters, obviously, but if you have a question for them, please put that in the general chat. And we ask that you just put in clarifying questions if you need a little more information about something that one of the presenters had said. If you have questions about strategy, that is when you can ask those in the breakout groups. We have Commissioner Lee from the Contra Costa Superior Court is one of our speakers, and she has to be very careful not to be seen to be advocating for one side or the other or giving any kind of information out about that, and that's why we have the separate breakout groups afterwards. So there is also going to be, at the end of the presentation, I'm going to be putting up a poll. The poll is going to ask you what breakout group you want to go to. You can answer anything. That poll is just for me to confirm you are here so that I can send you an MCLE attendance certificate. So that whatever you answer on there does not have anything to do with the actual breakout group you're going to go to. Let's see. I think, yeah. And again, if you missed it, if you did not let me know before what breakout group you want to go to, just private chat me that and I'll get that all set up. So with no further ado, I'd like to introduce our speakers. First, we have Samantha Sepehr, who is going to be our landlord representative. And she focuses her practice on elder financial abuse, civil litigation, and unlawful detainers. She served on the editorial board for the Contra Costa Lawyer for many years and is currently one of the co-editors. She's also served as co-chair of the Bar Association's Pro Bono section and is a current member of the Pro Bono Committee. She received her bachelor's degree in sociology from UC Santa Cruz, go banana slugs, and her law degree from JFK School of Law. Before graduating from law school, the Equal Justice Works Fellowship Program awarded her a 2-year fellowship to work with JFK's Elder Law Clinic, which is a nonprofit organization offering free legal services to victims of elder financial abuse. One of our tenant side attorneys is Adam Poe, who works for Bay Area Legal Aid. He joined Bay Area Legal Aid in 2008 as a housing attorney in the Contra Costa office, and he's been the managing attorney in that office since May 2018. And he became the first dedicated reentry attorney at Bay Area Legal Aid in 2012. And then took on the role of regional project coordinator for the reentry unit shortly after that. So in his housing practice, he's represented hundreds of low-income and disabled clients in unlawful detainers and administrative hearings in Contra Costa. And he maintains a caseload of housing and reentry cases and is involved in efforts to support individuals with criminal records to achieve stability through housing and employment advocacy. And let's see, he went to Michigan State with a bachelor's in poli-sci and DePaul College of Law. And we have Professor Ora Prochovnick. She's a full-time member of JFK's core faculty since 2008 and is the director of clinical and internship programs for the College of Law. She was previously professor at the New College of California College of Law for 21 years and a partner and founding member of Bayside Legal Advocates, a woman-run community law office in the Mission District of San Francisco, where her practice focused on tenant advocacy, non-traditional family law, and civil rights litigation.
Yeah, that's right.
Yeah. Guys, I'm going to ask that you please mute yourselves. Thank you. Professor Prochovnick has been frequently recognized for her pro bono contributions and has received many awards from the state bar and local bars and from community agencies in recognition of her expertise and legal assistance, particularly to the low-income community in the area of housing advocacy, assistance to persons with AIDS, and LGBT rights. And finally, we have Commissioner Jennifer Lee from the Contra Costa Superior Court. So she's currently in Department 54, dealing with traffic, small claims, unlawful detainer, and restraining orders, all the fun things that she gets to do. She graduated with a bachelor's in English and creative writing from Cal State Northridge, and then went to Penn State Dickinson School of Law. Has been a volunteer in many different things, including Project Lead and the Special Olympics in Southern California. She's currently president of the board of directors for the East Bay Children's Law, and she's member of the CCCBA Pro Bono Committee, and has had experience as a public defender, a staff attorney at Legal Aid, as a prosecutor in the LA City Attorney's Office, as well as the LA County District Attorney's Office, and also working for Apple in as security counsel. So she has had wide-ranging experience. So those are our panelists, and I am going to get started with our PowerPoint. Give me 1 second here. Okay. So I think Samantha, you're up first, and you're muted.
There you go. All right, thank you everyone for coming out and joining us on your Thursday evening. It's great to see so many familiar names, at least if I don't see your faces, and nice to see new faces as well. Again, my name is Samantha Sepehr, and I am going to be doing a overview of the California Tenant Protection Act of 2019. And you may be wondering, why are we doing that if we're supposed to be here talking about COVID and the rules impacted by COVID? The UD rules impacting COVID, the laws on unlawful detainers. Why are we talking about the tenant protection? The reason for that is because the laws have, this Protection Act has lots of laws in it that could be pitfalls for landlords, and you want to ensure that tenants are getting the rights that they're afforded under this law. So when we get the mad rush to the courthouse and everyone's filed their evictions and it's going to take some time to get to your case, you want to make sure for landlords that you haven't wasted time and resources getting there. And as tenants, you want to make sure that you were afforded all the rights that you were entitled to per the code and the law. So we're here to give you just a brief overview for some who may not be too familiar with it, and just a refresher for those who are already familiar with the Tenant Protection Act of 2019. So what is the Tenant Protection Act? It was signed by the governor last year and it went into effect this year. And it imposes rent caps on some residential properties in California. And it also imposes just cause eviction requirements that apply after a tenant's been in housing for so long, a certain period of time. The properties are exempt. There are certain properties that are exempt from rent caps and just cause. I'll get it together, I promise. There are some properties that don't qualify or don't meet the requirements of these protections, and we'll get into those a little bit. But just for an overview, if you're interested in learning more about just cause evictions, you should certainly look at Civil Code Section 1946.2. It's long, it's a little bit complicated, but it's definitely worth reviewing before you file any eviction to make sure that you're in compliance with that code section. And for rent increase limits, you should see Civil Code Section 1947.12. Now, the Tenant Protection Act of 2019 also added a third code section, and that's Civil Code 1947.13. We're not going to be discussing that much today, but that has more to do with rental rates for affordable housing. So if that's a situation that you're faced with, then you may want to also take a look at that code section, but we're not going to be necessarily talking about that today. Okay, so when we're talking, next slide, please. So again, new rent cap ordinance or laws, I guess, are under Civil Code Section 1947.12, and it applies to increases that occurred on or after March 15th of 2019. So why is that important for us now? It's always important to ask either your tenants or your landlords what their rent increases were between March 15, 2019 and January 1st of 2020. because if they exceed the limit, then the rent has to be adjusted. And for non-payment of rent, that could be a big issue because, as we all know, when you have your 3-day notice, it has to be exact. So you don't want to overstate the notice, or you're going to have to start back over again. So it's important to make sure that all rent increases between these dates are actually in compliance with the law. And what the cap is, it's a max rent increase of 5% plus CPI, or 10%, whichever is less. My understanding is that CPI is calculated annually in April, around April. You're not allowed to do more than 2 rent increases for the 12-month period. And as long as it's been within 12-month period and it doesn't exceed the cap. So there are, again, restrictions on how you can do it. So you have to look at the code section in order to make sure you comply so that your rent is at the right rate when you end up being able to serve a 3-day notice to pay rent or quit. And there is a sunset clause to expire this on January 1st of 2030. Next slide, please. So this Tenant Protection Act also does require certain disclosures, and it requires them in certain format as well. As you can see, AB 1482 requires 12-point type, and it's a notice that needs to be sent to new and renewed tenants starting on July 1st of 2020, and to existing tenants no later than August 1st of 2020. So we're past that deadline, but you should still make sure that notices or disclosures are given to tenants and that they're aware of these. Even if it's beyond, you should still do it. And here's the verbiage that needs to be put in those notices. And again, for tenancies that commenced or renewed after July 1st, this notice has to be in an addendum to the rental agreement or as a written notice signed by the tenant. And those that existed prior to July 1st of 2020, you have to provide the written notice or as an addendum to the rental agreement. Again, the date, make sure it's past the date, but we should get compliance on that if your landlords have not already complied with that. Next slide, please. So as I said earlier, this only applies to certain housing situations. It doesn't apply to all rental housing. So it does not apply to affordable housing in Section 8. It doesn't apply to homes built within, or I should say new construction built within the last 15 years, or single family homes and condos, specifically ones that are not owned by corporations. And if they're not owned by a corporation and they're exempt, you have to provide notice of the exemption to your tenant. It also doesn't apply to owner-occupied duplexes if the owner is a principal resident in one of those duplexes, and the tenancy is started after the owner moved in. It also doesn't cover rent control, presuming that the rent control in that city is more restrictive, and also doesn't cover dormitories. So these are the different types of housing you want to go through to see whether or not a landlord is exempt from this code section. Housing that is alienable and separate from the title to any other dwelling is also exempt. Again, these are the conditions, and the owner has to provide this notice to their tenants. It's codified in the code section, and this is the verbiage that needs to be given. And this is a condition of being exempt. You can't just not be a real estate investment company or a corporation and then not provide this notice. This is part of the element of meeting the exception. So this notice has to be given to your tenants if you're not subject to the rent limits imposed by 1947.12. So we've talked a little bit about rent limits and how that can affect your 3-day notices. There's going to be other landlords that want to terminate tenancy just based on cause. So California, again, has instituted just cause evictions, and it prohibits a landlord from terminating a month-to-month tenancy or choosing not to renew a fixed-term lease without providing a reason for the termination. And properties are exempt under just cause provision, and the rental relocation. I'm sorry, I'm hearing feedback. Does anyone hear any feedback? Sorry, I keep hearing an echo. So I'm going to try and get through this, but it's really distracting. But properties exempt from the rent caps are also exempt from just cause provisions and the relocation requirements. And additional owner-occupied properties are also exempt. So again, there are exemptions to just cause eviction. Requirements are that the tenant has to lawfully occupy the unit for 12 months, or I'm sorry, I hear the feedback, it's too distracting. Requirements apply after a tenant has continuously and lawfully occupied the unit for 12 months or more, or all of the tenants have lawfully occupied the unit for 2 years, 24 months. So there are 2 categories for just cause evictions. It's at fault or there's no fault. We're gonna go over those a little bit in more detail. Sorry, this background noise is just really, I don't know what it is. Thank you, Randall, I'll try that. So at fault just cause includes all of the following. It includes all of these items: a default in the rent payment, obviously a breach in the lease, a material breach of the lease, committing waste on the property, committing a nuisance. If the tenant also is refusing to execute a written extension of the lease, despite the lease being similar in duration and terms, that's another reason for just cause. Criminal activity, assigning or subletting the premises in violation of the lease, refusing the owner access to the property, using it for an unlawful purpose, or an employee's failure to vacate after they've been terminated, or when a tenant says they're going to leave and they give written notice of that, the owners accepted that and they still haven't left. These are all bases for an at-fault just cause eviction. So a little bit of the difference in this Protection Act is the law now requires that the termination include the reason for the tenancy being terminated. So why are you terminating the tenancy? Before, it was, some of the notices had that as an optional statement to put in the notice, but now they're required. You have to put it in there. And before the owner can issue a notice to terminate a tenancy for just cause, if it's a curable lease violation, the owner has to first give the tenant notice of the violation and give them the opportunity to cure. And if the violation isn't cured, then they can do another follow-up with a 3-day notice to quit. And that can be, that can sever it without the opportunity to cure. My question is going to be for some people that, and we can certainly talk about this more in the chat room, but if non-payment of rent is a just cause eviction, do you have to give a 3-day notice warning that you're going to then follow up with another 3 days because it's curable? Or is it just going to be 1 3-day notice and you can move forward? I'm not quite sure what the answer is going to be, but I was intrigued by that because I don't know how this is all going to work. If you do a 3-day notice and it's curable, or then they don't pay, do you have to, do it again? I'm not sure how that works out. So maybe I can ask Commissioner Lee. And then the other thing is if anyone wants to try and get around the just cause requirements, you can't. They put something in the code section that says that anything that waives the just cause requirements is contrary to public policy and is considered void. So for landlords who are looking to try and get around these requirements by putting in the lease, it's not going to work. So then we talk about no fault just cause, and what does that mean? What does that include? So no fault means these are the situations where a no fault just cause is what you can pursue if an owner intends to occupy the unit, including the spouse, domestic partner, children, grandparents, and parents. And for leases on or after July 1st of 2020, the owner can use this only if the tenant agrees in writing to the termination or if there's specific language in the lease. You can also do no fault terminations if you're going to withdraw your property from the rental market, or if you need to do substantial habitability repairs that requires your tenant to vacate the unit for a period of time and you need to get them out to make those repairs, that's also acceptable. Or if you intend to demolish or substantially remodel your unit. And the code section does provide a definition of what substantially remodel means. So if you're wondering if that applies to you, you can look to the code section to see if that applies to your situation and if you can exercise that. There's also the relocation disclosure and payment for no fault termination requirement that is new. So the landlord is required to make a relocation payment to the tenant if the termination is for no fault just cause. And a lot of my clients have been calling and are trying to get their properties off the market. And I'm, explaining that there's these new relocations. So it is something that my landlords didn't know about that's new. But I know there's other rent control districts that have it, but not so much in outside of Richmond and Contra Costa County. The amount of the relocation or rent waiver shall be equal to 1 month of the tenant's rent that was in effect when the owner issued the notice to terminate the tenancy. And there's also requirements on when those payments need to be made. It needs to be made a direct payment to the tenant equal to 1 month of the tenant's rent within 15 calendar days of service of the notice, or waive it in writing the payment of rent for the final month of the tenancy prior to the rent becoming due. If your landlord does the first option and the tenant does not move out, you can ask for those damages as part of the eviction if you aren't able to recoup those otherwise. So if you end up making that relocation payment and they don't move, then that is something that you could request back in your eviction. Again, you do have to notify the tenant of this relocation payment, and failure to comply with this is going to render your notice void. So if we've waited all this time to get into court for landlord attorneys, we get to the front of the line and you haven't complied with this, then we have to start all over again. So that's why this is really an important disclosure to make to your tenant and make sure that your landlords follow it, so that you don't get to the front of the line in court and just to find out that your case has to start all over for your failure to do that. Now, I've talked a little bit, well, I've tried to with this background noise. I talked a little bit about the rent control and the just cause. And again, that's for the state, but be mindful of the fact that the city of Richmond has its own. And the city of Richmond's ordinances are found in Richmond, California Municipal Code 11.100 et sec. So you can look there to see what rent control and just cause ordinances that the city of Richmond has. They have a little bit of a difference in regards to how much, how the rent can be increased. So if you, as a landlord's attorney, have landlords that have housing in Richmond, you want to make sure that you're familiar with this, because there's lots of rules and regulations for the city of Richmond that you should follow, or if not, Commissioner Lee will come. And then the rent increase, you have to provide them with a brochure, and they have reasons for 8 reasons that you can evict a tenant for just cause in Richmond. So I'm sorry that this has been choppy and a little bit, it's the background noise, but I think my takeaway from this is, or what I want you guys to take away from this is, not a lot of people are really talking about this act right now because everyone's stuck in the COVID ordinances and the rules, rightfully so, on what's going on. But because, like I said, we're waiting for landlords and to get into court to pursue these cases, you have to make sure that you take a few steps back and comply with the rules that came into effect starting in January, because you don't want to get to the front of the line just to find out that your landlord has not provided the proper notices regarding the increase in rent, or there was a rent increase that was not up to code, and then you have to start all over. And in looking at this, there's still some, it looks like, gray areas. So again, the takeaway would be, because it's going to be overwhelming once we get back into the court and the courts are going to be backed up, hopefully this is an opportunity for both sides of the bar to work together, landlord and tenant attorneys, to come to resolutions to get us through the system sooner rather than later. But if this stuff went fast, if it's confusing, I apologize. It is very overwhelming with everything that's going on with COVID when you add that to it. But I think it's an important piece of the pie if we're going to get to court to make sure that everyone's done what they were supposed to do and that all the protections afforded to tenants are actually given to the tenants. Does anybody have any questions?
I don't think anything's in the chat. I did want to just let everybody know that I will be sending the PowerPoint out after today's presentation. So you will have the opportunity to see all of the great information that everybody's put together. So thank you, Samantha.
Sorry for the feedback, you guys, and the choppiness. It's hard to talk this way.
You sounded fine on this end.
Okay, good. Thank you.
My turn. I guess so. Hi, everyone. Again, my name is Adam Poe. Thank you for having me on this panel, and thank you for the introduction, Teresa. I feel like I should cut that down a bit, but I do appreciate being here. If folks don't know, I wanted to just say for a minute what my organization does. Bay Area Legal Aid provides free legal services to the lowest income and the most vulnerable across 8 Bay Area counties. And I'm the managing attorney of the Contra Costa regional office, and we are based in Richmond. We serve all of Contra Costa. We have a handful of different practice areas, all of which touch on tenants' rights, housing rights, fair housing issues in some way. In some respects, I'm not the logical choice to give a legislative update. For one, I have no particular policy expertise or insight into you know, the sausage making in Sacramento or DC right now. But I did find this exercise helpful, and before I forget, I want to thank my summer law clerk, David Pankert, who put together a really terrific summary. The other reason is that, generally speaking, our organization isn't permitted to do lobbying. That is, you're not going to see me or my staff, generally speaking, you know, blowing up the, you know, Board of Supervisors meetings and all of that. That's generally prohibited, although we can speak to our client experiences. And I wanted to do that just very briefly before we move on. I don't think it's controversial to say that absent some kind of dramatic intervention in the very near future at either the state or federal level, we're going to see a really crushing and destabilizing impact on tenants. And I know Aura will probably touch on a lot of that in her presentation, but I wanted to make sure I mentioned that, particularly in this environment of you know, public health consequences could be drastic too. I think they're unknown in some ways. I started practicing in Contra Costa in 2008, and in the middle of the, you know, as a baby attorney in the middle of the foreclosure crisis, and the destruction and the displacement and the loss of equity, most of which is borne by communities of color, is something I'm afraid that we're on the cusp of yet again. And I wanted to start there because we really are looking to our elected representatives to intervene in some way, and which brings me to this piece I wanted to present. And again, I can give some insights as to where these may be headed, but on others, I imagine there's folks on this panel or in the audience that might have a better sense than I do of where this is headed. So this particular piece, SB 1410, I imagine folks have heard about it. Essentially what it does is allows tenant and owner to enter into a voluntary repayment agreement, and in return, the tenant then repays over some extended amount of time back to not to the owner, but to the state, while the owner receives a tax credit, which it can then turn around and sell. Now, one of the at least from the tenant perspective, one of the criticisms of this bill is that the entering into this agreement is entirely voluntary. And if the owner chooses not to, then they would then be free to move forward with an eviction, which is why you know, sort of that I think uneven bargaining position is one of the reservations a lot of tenant advocates have. Now, if you pair something along these lines with the next bill, which does offer tenant protections, but again, it doesn't offer much in the way of you know, return to owners and landlords, then maybe there's some kind of combination in there, some kind of a compromise. This bill is almost entirely tenant focused, AB 1436, which allows a 90-day window following the expiration of the state emergency, for which a landlord may not evict the tenant for non-payment of rent during that window. So that's a 15-month window, because it, including that 90 days, allows another year for the tenant to repay what was owed during that state of emergency. And another feature of it is not only does it allow them that 15 months, but if they fail to repay after that 15 month, the landlord may use normal civil remedies to collect, but not unlawful detainer. So then we're looking at something that's like a contract action essentially, but would not result in eviction. So this is something that a lot of again, tenant advocacy groups are in support of. I imagine that there's opposition to it. And Contra, if you don't mind, I think we can skip this one. I don't think it's terribly interesting, nor is this one. Although I guess you know, I think it is important to you know, to at least note that there is some action around the idea of allowing owners to have some relief from their mortgages and from potential foreclosures for non-payment of mortgage. And that's when this one does, for a short window after the state of emergency is ended. And I should also mention, sorry, I believe it's SB 1410 also includes provisions for mortgage relief, so that again, it's hard to imagine that maybe one or the other of those bills might pass, but together it makes some sense and provides some relief to both tenant and landlord. So that, knowing as little as I do about, again, the sausage making process, it seems like there might be some kind of winner in the combination of those bills. So looking at the federal landscape, I imagine folks have heard of the CARES Act, which has a lot of different provisions. This is the housing focused one, which provided some protection from non-payment of rent evictions for covered properties. And I guess starting there, covered properties, I think the easiest way to maybe of shorthand for understanding what that spans is most federally subsidized programs. The exhaustive list is in reference to the Violence Against Women Act, VAWA. So if a property is bound by the VAWA provisions on refraining from evicting survivors of domestic violence, then it is also covered by the CARES Act limitations on evictions. So again, public housing, project-based programs, and rehab programs and tax credit programs, which is obviously a large stock in Contra Costa. So what it accomplishes, or what it seeks to do, is prevent rent evictions, but for once the act itself expires, which it did a couple weeks ago, and then upon 30 days notice. So we're at that point now. I imagine what the Monday following July 24th, I'm assuming that there was a bunch of 30-day notices that went out on the CARES covered properties, although I don't know that I've seen one yet personally, which is maybe a good sign, maybe a little surprising too. Right, so there's nothing, the CARES Act does not speak to any reason besides non-payment of rent. I think one gray area, or at least from my perspective, would be a no cause termination where there is a possibly a motivated by non-payment of rent, but I think that's a gray area. No cause terminations are not in the black letter of the CARES Act. Again, having expired on July 24th, I mean, I think it's fair to say that it is still in effect in some respects, although what we're really talking about is the notice period. So it extends indefinitely. In other words, tenancy cannot be canceled, terminated for non-payment of rent for the period of the moratorium until after the notice is served and expires. And default to state law would mean that it doesn't speak at all to the form of the notice, nor to the manner in which it needs to be served. So that would revert to California law. And here's, where I think anyone's guess is as good as mine. There are a lot of terrific provisions in the HEROES Act, a lot of relief for tenants, a lot of relief for homeowners, a very strong and unqualified eviction moratorium. This was passed, a few months ago now, and I don't think anyone knows what, if any of this will remain in whatever is ultimately passed, if anything is ultimately passed. Thank you.
Great, thank you, Adam. And I think Commissioner Lee, you are up next.
Great. Thank you, everybody, for being here tonight. So I'm just going to talk briefly about the filings. And this has been a real issue. And even the courts, we're still trying to navigate what filings we can accept, because every time we turn, there's a new rule. Some by the governor, some by the county, some by city ordinance, and it's just changing constantly. So the compliance that the courts have to follow are mandated by the executive order N3720, which has been extended to September 30th, 2020. The compliance is also mandated by the California Rules of Court Emergency Rule Appendix 1, the Contra Costa County Emergency Rules Civil Fifth Amendment, the Contra Costa County Board of Supervisors Ordinance 2020-20, unless the number may be off, it may have been updated again. The City of Richmond, fourth supplemental to the order resolution number 74-20. And I went on today and I think they may have updated again, and other city local ordinances. These relate to both non-payment of rent and notices to cure or quit, which are based on the public health and safety. And if you look at the city ordinances, they do, and the county ordinance, they do require certain written notices that appear to be more for non-payment of rent, but are required in every, at least the way the ordinance reads, appear to be even for health and safety, public health and safety. So we can go to the next, and Aura is going to touch more on those rules in a moment. So basically what the executive order says, and it's been extended until September 30th, is that the deadline for the civil code for 1167 is extended for a period of 60 days for any tenant who served while this order is in effect with a complaint from a resident for non-payment of rent. So Any complaint prior to April 6th that was for non-payment of rent goes 60 days, and that's also in conformity with the California rules of court. However, the way the ordinance is written, and if you see it, what it talks about is it's non-payment of rent unless the following occurred. So if let's say they're not paying rent now, but someone files non-payment under this ordinance, if they comply and show that prior to the filing, prior to COVID, that they were paying rent, provided notice in writing to the landlord that they were affected due to COVID, retain verifiable information about their income, then there can't be an eviction under, it creates an affirmative defense under a non-payment case. The deadline to answer under this ordinance and under the emergency rules, which I'll get to in a minute, is extended from 5 days to 60 days. And no writ may be enforced for non-payment if the tenant satisfies paragraphs A through C of the executive order. This is from cases post April 6th. Okay, we can go to the next slide. So Appendix 1. The court cannot issue a summons on a complaint for an unlawful detainer unless the court finds in its discretion and on the record that the action is necessary to protect public health and safety. So essentially, every petition that's filed with the court, I make at least in my court, I make a record if I am going to grant it or deny it. That way, if anyone wants to writ a denial, there's an actual record where I state the reasons on the record, and those reasons are also encapsulated in the written order. But it does provide for an electronic record. This is made without the parties being present, and like I said, I make it regardless of whether I'm granting it or denying it. But it has to be to protect public health and safety. This is different than when a summons has already been issued prior to April 6th, prior to the shutdown. These are for the new ones. The declaration has to be under oath. And oftentimes what will happen is that an attorney will submit a declaration under oath based on what somebody else told them. That may not be sufficient because that's filtered facts. And it needs to be specific. It has to show specific incidents or instances, including dates, additional, police reports. You can include those. You can include anything, but it's basically where more is better. And if it's not sufficient, it's going to be rejected pursuant to the Fifth Amendment Rules of Court 3D Romanet 3. And then there also needs to be an order that's included, a proposed order. Now, with pro pers, they may not know how to create an order, and there's not a form online. So there is a little leeway for pro per landlords, but they do, even pro pers have to submit it under oath or penalty of perjury before the court can review it. The majority of the ones that have been rejected have not been rejected for this. So we can go to the next slide. They've been rejected for this reason. The majority of the proposed or the requests have not been served on the tenant. The local rules of court, Fourth Amendment, Third Amendment, and the California Rules of Court require that ex parte notices still be served on the opposing party. Under the rules of court that were amended to make this more clear, and they were modeled after what other counties have been doing, the tenant may also file an opposition, but the court's going to make a ruling based solely on the moving papers. It's not going to be a mini trial about whether this should be granted and then reiterate everything further in a trial. It's going to be limited to any opposition that's filed, reviewing the moving papers, and then if the court finds there's sufficient information, the court will go ahead and grant the order for the summons, and then there can be a fuller, more robust hearing and a trial. If there insufficient evidence, or like I said, the tenant has been served, it's going to be rejected without prejudice. There needs to be a proof of service or something attached, or if there's insufficient service information about health and safety, public health and safety, that can be supplemented as well. There's no problem with that. Okay. The court can't enter a default judgment for restitution in an unlawful detainer for failure of the defendant to appear unless the court finds both of the following: the action is necessary to protect public health and safety, and that the defendant has not appeared in the action within the time provided by the law, including by an applicable executive order. So breaking it down, any non-payment of rent case that was filed before the moratorium that falls under that 60-day exception allows a defendant to respond within 60 days. If the defendant doesn't respond in 60 days, let's say they get wind of this and they just say, oh, you know what, I'm not going to file an answer, because the court can't enter a default. Even if it was filed prior to the moratorium, prior to all of that, and no answer was filed, and it was extended to 60 days, or because it's at least 60 days, it can be longer than 60 days, at least 60 days, and the defendant never files an answer, the court still can't proceed on a default. The default is only for public health and safety. It has to still show that there's an ongoing emergency or threat to public health and safety. It's not enough to just evict somebody based on the fact that they didn't respond, like pre-COVID, where defendant doesn't answer, the time has run out, we're within the 45 days, and a default judgment can be entered at the clerk's window. Not only can they not be entered at the clerk's window, the court has to order them all. And again, if it doesn't meet these requirements. In order to enter the default for public health and safety, there has to be an affidavit. The affidavit is necessary to show why the default needs to be entered. It's not enough to just go back in time. So for example, there have been some filings where this was pre-COVID and these were 3-day notices to cure or quit, and they were on OC calendars, and then nothing happened and they just kept getting continued. And now we're in July and they want to enter a default based on the behavior issues that existed in December. Well, that's not showing an immediate threat to public health and safety, and then that's going to be denied. But even for non-payment of rent cases at this point, anything prior, there's no default. There's just no default that's going to be entered at this, because it won't comply. We can go with the next slide. Okay, and this is what I was touching on. If a defendant has appeared in the action, the court may not set a trial date earlier than 60 days after the request, unless the court finds that an earlier trial date is necessary to protect public health and safety. The court can do this on its own motion or a request from the plaintiff with an order shortening time, but it needs to set forth good cause for protection of public health and safety. So these are the ones where, again, it may be non-payment of rent from prior to COVID, which would then go out the 60 days. And if something has changed or there's a threat to public health and safety, that's one thing. But for these emergency ones, there can be a request for an order to shorten time, so it's not set out the 60 days. I have only done one emergency trial thus far. Like I said, the majority have been rejected because they haven't complied with the notice requirements. And then the one that I did, the threat was so immediate that on my own motion, I scheduled it for earlier rather than later. But if you feel that that's something you want, that should be included, or that request can be included as well. Okay, and next slide. The unlawful detainers prior that were filed before March 16th, the summons was issued. You can still request posting orders if you haven't been able to get the person served. And then, like I said, any trial must be continued at least 60 days from the date of the initial trial if they were already set. So what it looks like starting in September, some trials are going to start happening again. But then there's other questions that are raised, and these are probably better for the breakout rooms, of what are holdover damages and what can you get? Because if there's non-payment and they've showed verifiable income, would they still be eligible for holdover damages? And that's going to be for the attorney advocates. But those are some things to consider. Okay, we can go to the next slide. Oh, and that's going to be Aura. So mine was very brief because Aura's got the big, she's got every ordinance in Contra Costa County.
All right. Thank you so much, Commissioner Lee. Really appreciate you. Okay, Aura, you're on.
All right, bringing up the rear, I want to echo what all the prior speakers also mentioned, which is to express a great deal of gratitude to everybody for attending this. And in particular, to follow up on what Adam talked about, which is the drastic impact that is already affecting people and how much more it's going to after this moving target of a date, which right now we're looking at is probably around September 30th, but can change. In terms of people who are already barely marginally housed, living paycheck to paycheck with very high rents and low wages, just trying to stay sheltered for themselves and their family, being at jeopardy because of the impacts of COVID on our economy and these evictions. And we saw some potential protections on a more permanent basis in the state legislation that Adam mentioned, but there's really going to be a flood of litigation that is causing me to want to do a little bit of a pitch for people considering putting in some time on some pro bono work. That I know that there's been a heavy interest expressed in the landlord breakout room, and I want to sell the tenant breakout room as something to consider, both because you'll learn some things about how to represent the landlord side from thinking about the other side, but also that I would really like a lot of people to be thinking about the needs for our community as a whole to have some pro bono assistance to these tenants who are going to be in dire need. So that's the foundation for what else I'm going to be talking about, which are these local orders and ordinances that Commissioner Lee has already referenced. So there is a very complicated layer of protections that depend on where the tenant lives. There's the statewide protections, which Commissioner Lee has addressed, that come to us from the Judicial Council rules, and a slight state moratorium that doesn't have significant impact. There's a county-wide ordinance, and then there's individual ones from different cities. So for doing unlawful detainer work going forward, whether landlord side or tenant side, it's going to completely depend on where the tenant resides, where the subject property is located, and that's how you're going to begin your determination of what rules apply. And then, of course, the dang rules keep changing. So on top of figuring out where the tenant lives, we're also going to have to keep up on the current laws. So we're going to go through each of the different major cities in Contra Costa and look at what laws are applicable there. And I did try to make these as current as I could, so I did update them with the most recent version of each ordinance. And as Teresa said, you'll be getting a copy later of this PowerPoint. So if you want to, each of these next slides has a link to the specific local emergency ordinance that's applicable to that city. Overarching is the Contra Costa County ordinance. So we'll talk about that ordinance as well. The county ordinance applies to properties in all 19 cities in the county and in the unincorporated areas. However, if there is a local city council enacted ordinance, the local ordinance is going to apply instead of the county ordinance. So you've got this countywide ordinance that will apply in all the unincorporated areas and in any city that did not create its own regulation on this subject. But if there's a local regulation, whether it's stronger or weaker than the county one, it's the local one that will apply. All right, as we go through this mishmash of different city ordinances, I'm going to do it fairly quickly because we only have 15 minutes to talk about this, but you'll see some sort of commonalities between them. So for each one, you're going to want to look at the type of ordinance, meaning is it protecting a tenant just around issues of non-payment of rent, or does it also apply to other types of evictions? So we'll see that distinction between them. We'll see some distinctions between them about what does the tenant need to do in order to invoke the protections of this ordinance. And in most cases, there's some requirement of notice to the landlord, some documentation, and some variability on what qualifies the tenant for the specified protection. There's a range of information in these different ordinances in terms of what the payback period is. So we'll look at the different effective dates, but there's some window of time after the effective date by which arrears will have to be paid back, and you'll see quite a wide range between the different cities. We'll see a range of ordinances that give the tenant an independent right to sue after violations or ones that don't. And you'll need to look at the effective dates. So what was the target date in which this protection kicked in, and when does it continue to? And happily, most of them are written in a way that ties the termination date to the state of emergency declared by the governor, so that rather than the city council having to go back and rewrite it, which a few of them had to do, instead, they're all gonna last as long as the state protection lasts. So right now, that September 30th date that's already been thrown out is gonna kind of apply across the board. So those are just some overarching concepts to keep in mind as we go through each city one by one. And as there was no particular reason to do it in any other order, we're going to look at them alphabetically. So we are starting with Antioch. And Antioch's ordinance applies to any notice served after March 16, 2020. And it will expire on the date of either the local declaration of emergency ending or the governor's statewide proclamation ending, whichever is later. So right now we're looking at a September 30th end date, but it's a moving target. The payback period in Antioch is a 90-day grace period for each month. So it's a little bit complicated. If a tenant has not been able to pay rent for 2 months, they're going to have 180 days to repay it. So however many months times 90 days. The ordinance prohibits a landlord from charging any late fees or other charges because the rent was delayed. And the tenant has to give notice within 14 days after the rent was due about their inability to pay the rent and some documentation of that inability. So that's the language and requirements of the Antioch notice. And we can move on now to Concord. The effective date is March 25th, so you could see it kicked in a little later than Antioch. If the tenant was not able to pay rent on March 17th in Concord, it doesn't come within the protection. It again is automatically extended as long as the governor's order continues to be extended, so currently through September 30th. It has a similar grace period on arrears, so it's again the 90 days for every month that the tenant is behind. There's once again that prohibition on late fees or penalties. They added in sort of this protection against preemption, so if there's some state law that allows the late fees, it kicks in, but that shouldn't really change things. The notification here is a 7-day period, so within 7 days before the rent was due, the tenant was required to notify the landlord in writing of their inability to pay and provide some documentation within another 3 days after the rent was due of why they couldn't pay. And I'm going to encourage you to take a look at the actual ordinances because there is some variability in terms of what constitutes a substantial decrease in household income. It's usually either justified by unemployment or severe medical costs or childcare costs, inability to go to work because their kids are at home with them. This ordinance, the Concord one, only applies to evictions for non-payment of rent. It does not provide additional protections for other no-fault evictions. We'll see there's other ordinances that are different than that. But it does have this added provision, which you'll also see duplicated in some of the others, where during the time of the emergency, there can be no rent increases for the tenant. So early on, Samantha was talking about the applicability of AB 1482 and how it creates rent increase protections. If a unit is exempt from AB 1482, Concord does not prevent those rent increases, but any unit that has to comply with those statewide rent control rules has 0 rent increases. So that cap of 10%, CPI plus 5% is told for the period of the emergency. Moving on from Concord, we move to El Cerrito. El Cerrito's kick-in date was March 16th. It also is tied to the governor's proclamation of emergency in terms of its ending date. This gives a 6-month period of time for payback. So the rent that accrues during this period of emergency will be due back to the landlord with a window of time of 6 months after the emergency is over. There's a prohibition on any late fees being charged, and there is a notification requirement so that within 30 days after the rent was due, the tenant had to provide written notice to the landlord. And for all of these ordinances, that written notice does include the ability to notify by text or email. Moving on from El Cerrito, the next slide. So in Pinole, we have a start date of March 16th for the local protection, but a fixed expiration date of May 31st. So this ordinance did not tie to the continued extensions with the governor's ordinance, and so Pinole's ordinance is no longer in effect. The county ordinances therefore will still apply going forward from May 31st on. Tenants were protected from non-payment of rent only in the window from March 16th through May 31st. From that end of May period, there was a 4-month payback period. So they had 120 days to pay back their arrears. Once again, a prohibition on late fees, although once that 120 days expires, if the tenant has not repaid the rent, landlords can start to charge a late fee starting with that time. And for this protection to have applied to tenants, again, it's too late now. It won't be able to apply going forward, but for the past rent, tenants should have notified the landlord within 30 days of the due date for the rent about their inability to pay. Moving on to the next slide. Pittsburgh's ordinance, you'll start to see some familiarity, kicked in March 16th and does not expire until the local emergency is terminated. So Pittsburgh did not tie to the statewide declaration of emergency, but it still is ongoing as long as that there is a local emergency in Pittsburgh. The tenant has 6 months after the termination of the local emergency to repay the accumulated back due rent. The Pittsburgh ordinance is more specific than some of the other cities in terms of a partial inability to pay. So if, for instance, a tenant has been cut back to part-time work and they used to work full-time, it might not mean that they can't pay any rent, but they need the rent to be cut back 50%. So when they give notice of their inability to pay, it has to include some statement of what percentage of the arrears they're able to pay, and they have to continue to timely pay the prorated share, or they could still be evicted. So this protection only is 100% relief from rent payment if the tenant can show that their hardship is 100%. There's a prohibition on the landlord charging late fees once again. The notification period here is 15 days after the rent due date. And the documentation has to be provided to support that claim. The Pittsburgh ordinance is protective beyond non-payment of rent. It also prohibits any no-fault evictions. So if the tenant is current on their rent, but the landlord has their own reasons to evict that come within the state law for just cause, such as they want to do an owner move-in eviction for themselves or a close relative, or they want to go out of the business of being a landlord, or any of those reasons, those are all currently prohibited in Pittsburgh during the period of the emergency, unless it comes within that health and safety exception that Commissioner Lee talked about. The City of Richmond's effective date is March 17th, so one day later than some of the other ones that we saw. And it is tied to the duration of the local emergency. So that's currently a September 30th end date that will automatically be extended if the local emergency is extended. The payback period here is 1 year after the expiration of the emergency. So sorry for the typo in there. It's not currently 9/20/21, it's 9/30/2021. So if the emergency ends September 30th, 2020, if it's not extended, tenants will have an entire year until the end of September of 2021 to pay back the unpaid rent. Once again, the prohibition on late fees and the notification requirement is 30 days within the date that the rent was initially due, and documentation of the reasons that they are financially impacted. Richmond, also like what we saw in Pittsburgh, it includes a moratorium on no-fault evictions, with the same exception that if the no-fault eviction is necessary for the health, safety of tenants, neighbors, or landlord. Clearly, that's not a no-fault eviction. That would be a fault eviction. That would be an exception to the moratorium. So basically, in Pittsburgh and in Richmond right now, there are no evictions allowed for any reason except health and safety. The San Pablo ordinance applies to notices after March 16th, 2020, but only if the tenant was current on their rent at that time. So it's an interesting little tweak on the way the protection works. If the tenant was behind on their rent on March 16th, they lose all of the protections, in theory, even though their continued inability to pay rent is due to COVID. The expiration of the San Pablo protections are based on city council extensions linked with the statewide ones through the governor. This one is similar to what we saw in Pittsburgh, which is there is a pro rata reduction of the rent based on the tenant's ability to pay. There is the 365-day repayment period. If we could go backwards, so the 365-day repayment period is similar to what we saw in Richmond. Prohibition on late fees, a requirement of notice to the landlord within 14 days. Again, it applies to other grounds for eviction beyond non-payment, but the landlord can terminate not only for the explicit health and safety violations by the tenant, but it makes it very clear that if it's necessary to protect the landlord's health or safety. So arguably, perhaps where the landlord needs to relocate him or herself, or relocate a close family member into the unit because they're not able to safely stay where they are, that would be a reason where they could terminate. There is a sort of a fine tuning of that tenants can expressly prohibits evicting a tenant for having unauthorized occupants in their unit if the person who's moved in with the tenant is a family member of the tenant who's sheltering there because of COVID. So there's just a recognition that occupancies of different units has to change to keep people off the streets and sheltered during this time period. And there's an express prohibition on rent increases in San Pablo, except for those that are exempt from the AB 1482. Now we can move on to the county-wide ordinance. So again, this county-wide ordinance applies to any of the unincorporated areas or to any city that I didn't just mention that has an ordinance in place. It became effective on April 21st, but was retroactive to eviction notices and UDs that stemmed from March 16th onward. It doesn't apply if the tenant already gave up possession or had their UD adjudicated before April 16th. The effective date of this is through September 30th, but will be extended if the Board of Supervisors extends it due to continuance of the emergency. This September 30th date is already the result of several extensions. The payback period on rent is 120 days from the time that the emergency period has expired. So right now, with our ending date of September 30th, the tenant will have until January 30th of 2021 to repay. If the September 30th date gets kicked over, it will always be 4 months down the road when the repayment has to happen. No late fees until after that 120 days has run. The tenant has to give notice in writing before the rent is due or within 14 days after it was due, including documentation of why they should have protection from having their rent due. Contra Costa's ordinance also applies to prevent no-fault evictions. Includes similar language to what we just looked at to not allow an eviction for an unauthorized occupant if they're there in order to get shelter during COVID. And it prohibits rent increases during the period of this ordinance, during this emergency period, unless the unit is exempt from the state rent control protections. So basically those single family unit type protections. I wanted to conclude just to also get on people's radar that statewide there is a law that prohibits price gouging. This is not limited just to housing situations, and it wasn't passed because of the COVID situation. The California Penal Code has had this long time prohibition on price gouging at any time during emergencies, during disasters. It was frequently used for protection, for instance, after the statewide and county specific disasters, after all of the fires that we've been having. So the protections of Penal Code 396 kick in if there's been a proclamation of a state of emergency either by the president, so nationwide, by the governor, or locally. And we have all three of those working right now. The anti-price gouging stays in effect until 30 days after the end of the emergency period. And it prohibits basically profiteering. So just as during an emergency, the local grocery store can't triple the price of bread, it also prohibits a great increase in rental rates, and it's defined as 10%. So it's actually the only form of statewide rent control that we have on vacant units. It doesn't just apply to protect current unit tenants, but if somebody moves out and a new tenant should move into that unit, the price gouging law prohibits the landlord from raising the rent more than 10% higher than what it was just prior to the state of the emergency being declared. So this is an extensive potential protection for people who reside in cities outside those that we mentioned that prohibited any rent increase at all during this time period. And the penalties for violation of this are quite severe. First of all, there's criminal penalties. It is a penal code violation. So violators face fines of up to $10,000 and up to 1 year in jail. And there's also civil enforcement with actions can be brought for civil penalties of up to $5,000 per violation. And we find in our office that usually just writing a strong letter can alert a landlord to why their attempt to raise the rent was not going to be allowed.
All right, great. Thank you so much, Aura. Gonna stop the share now. I don't think we had any, do we have any questions in the chat, Constance? Let's see.
No, there's no questions.
Okay, Great. All right, like I said, I'm going to send out a poll to everybody. I just need you to choose. It's going to ask you the breakout group you want. You can choose anything. This is just a way for me to verify your attendance so that we can let the state bar know that you were here. And while you guys are doing that, I'm going to finish setting up all the breakout groups. So there is the poll. And get all these set up. And I would like to thank again all of our speakers. You guys did a fantastic job. Ton of information there. Like I said, I will be sending everyone the PowerPoint either later today or tomorrow. And let me just. Okay, great. So some of you guys, I managed to preset into breakouts. So I'm going to send everybody who I've preset into the breakout rooms right now, and then everybody else just give me a couple of minutes to get you all there, and we'll get going. So what you will see, if you haven't done the breakout groups in Zoom before, you'll see something that'll come up on your screen saying you are going to breakout group 1, 2, or 3. You can click OK. If you don't, it will automatically throw you in there in about 60 seconds. And if you happen to have if you have more than one screen, sometimes you might have to look behind something on your other screen. Sometimes that part gets lost. So, and if you get in the room and realize you're in the wrong one, you can leave and you'll come back to this main room, and then I will throw you into the appropriate breakout room. So here we get started. Okay, and I will start adding the rest of you people. If you have not let me know where you wanted to go, just shoot me a quick text. Or sorry, a chat. Let's see. And if you do not want to go to a breakout room, you can just head out right now. All right, Benisa, where did you want to go?
Tenant.
Tenant, okay, great, thank you. All right. Oh, Terry, where can I send you?
Landlord, please, Teresa.
All right, thank you.
Thank you.
All right, and okay. Ray, where did you want to go?
Landlord.
Landlord, okay. Sorry about that. Not all of
No
these
problem.
went there for some reason. Okay, you should be good now. All right, Jeff, Thayer, where do you want to go? Landlord?
Hi, actually, can you send me the court?
Sure. There
Thanks.
you go. Vahishta? You still? Yeah. Where can I send you?
Court, please.
Okay, I should have known that. Corinne.
Court, please.
All right. Joel. Oh. Okay. Robert, how about you?
Landlord, please.
All right, thank you. Okay, there's someone who's on the phone, and I think I can send you there if you want to unmute and let me know where you want to go. Oh, okay, Constance, where do you want to go?
Hi there. I'll go to the court.
Okay, great.
Thanks.
All right, Joel, if you're there, I can sign you. Oh, hey, Abby, did I send you to the wrong place?
Yeah, I was hoping to go to the court,
Yeah.
with the commissioner.
Yep, I know. I'm sorry. I realized right after I sent you there.
That's okay.
Okay, so let's see. Okay, that should work.
Thank you.
All right, I still have Joel and the person who's on the phone with area code 317. Happy to send you to a breakout room if you want to.
I haven't seen the invite yet.
Do you have more than one screen? Because sometimes it's hiding
Let me check.
and it might be like hiding behind something else.
Yeah, I don't see anything.
Yeah, because it's got you. It just says that you haven't joined yet. Let me see. There's something I can do. You know, Abby, can you go out and then come back in? That might be easier.
Yeah, I'll do that right now.
Yeah, sorry.
That's okay.